Thank you, Thea. We're so excited to have Marcy with us today. Just a little bit about her. She has been mediating for over 20 years. She first received her training in Las Vegas at the Neighborhood Justice Center, and she's currently the Senior Housing and Employment Discrimination Mediator with the Texas Workforce Commission. She's a TMCA distinguished or credentialed distinguished mediator. And she recently presented at the TAM conference, and that's kind of how we came to know about Marcy and invited her to share, her knowledge with our group. So welcome, Marcy, and I'll turn it over.
Thank you. Thank you all guys for having me. It's such an honor. As Michelle stated, my name is Marcia Anavitarte-Jordan. I usually just go by Marcy Jordan because Anavitarte is a lot to kind of put in there. I am a senior mediator, housing and employment with the Texas Workforce Commission Civil Rights Division. I've been there for 9 years. So I've done quite a few mediations. My role there is strictly mediation and conciliation. I am trained as an investigator, but I mainly do just mediation. So I mediate roughly about 5 days a week. Sometimes I get a break or not. So adding that up in the years, I've done well over 1,800 mediations. So got a little bit of experience behind me, just a tad bit. So we're going to go ahead and get started with my presentation. During the presentation, if you got any questions, feel free to stop me, ask questions, pick my brain, whatever the case may be. I'm not one of these formal, you got to go through all the slides and wait to the end. I'm not like that. That's too formal for me. I tried it once. It was an epic fail. So I'm just laid back and everything else. And I hope you enjoy my presentation. So it is on housing and employment discrimination cases, navigating the new landscape post wonderful, great, fantastic COVID. So what is employment discrimination mediation? Now, what that is an individual feels like their rights have been violated in the workplace, and that's based on Title VII, which is the Civil Rights Act of 1964. You have the Equal Pay Act of 1963, so that was pre the Civil Rights Act. You also have the Age Discrimination and Employment Act of 1967. You have the Americans with Disability Act, or the ADA, of 1990. You have the Pregnancy Discrimination Act of 1978. You have Sexual Orientation and Gender Identity Discrimination, which was recently passed about 2 years ago with the Supreme Court. Now, those kind of cases can be filed with either TWC, which is Texas Workforce Commission, or you can file them with EEOC. A lot of people like filing them with TWC because we have just a tad bit smaller caseload than EEOC. So we try to get them in, mediate them if all possible, or they go to investigation and get them a determination. So we're kind of busy over there. So that's what employment discrimination is based on. Now, you also have housing discrimination. And a lot of people don't realize that TWC does housing discrimination as well, but we do. We're the best kept secret around. In these kind of cases, you could either file with TWC, one of the housing, fair housing councils, or you can file it directly with HUD. But what housing discrimination is, those cases are filed by individuals who feel that their rights have been violated, and that's part of Title VII, which is the Civil Rights, Title VI of the Civil Rights Act of 1964, Section 109 of the Housing and Community Development Act of 1974, Section 504 of the Rehabilitation Act, which is your disability, Title II of the Americans Disability Act of 1990, Architectural Barriers Act of 1968, Age Discrimination Act of 1975, and Title IX of the Education Amendments Act of 1972. So we got all of those kind of combined in there. So the only difference between employment and housing is with housing, you also have a familiar standard as one of the bases for discrimination. Whereas with employment, of course, you don't have familiar status, you have pregnancy. So it's kind of like before the baby gets here, and then housing deals with after the baby gets here or after the children get here. So, oops, sorry. Told you about housing, told you about employment. So what exactly is employment and housing discrimination cases? So basically what happened is the EEOC mediation program was established in 1991. And they thought it was a good idea, best way to get rid of cases, because all cases don't need to go to litigation. So this was a perfect opportunity for EEOC going, hey, look, this is, let's go ahead and do this. The mediators are trained. They are required to be trained. They got to have their 40 hours. And EEOC said, okay, cool. Then what the Texas Commission on Human Rights Human Rights, which is TCHR, that was in 1983. That was established to handle discrimination cases, whether it's housing or employment. Then in 2004, TWC assumed it, but it hadn't been, that agency had not been sunset as of yet, or I guess put out of commission, retired or whatever you want to call it. And then in 1913, then TCHR was combined into TWC. So now we are part of TWC, which is, we're called the Civil Rights Division. So we are actually an agency within TWC, and we do all those wonderful cases throughout the day. So now, what exactly, all this garbage that I just rattled off, what does it mean? What does this law mean? It's just basically saying that if a person that's in the workplace feel like their rights are discriminated, we're talking about age, race, color, national origin, religion, disability, sex, sexual orientation, and transgender, equal pay, pregnancy, and retaliation for filing a complaint. So those are the things that we mediate and investigate over at TWC. For housing, it's basically the same thing. If a person feel like their rights are violated, and that's also, race, age, color, national origin, religion, disability, and familiar status, which is family. Some apartment complexes, some property managers say, hey, you can move in, but your kids can't do that. It's discrimination. So the only difference between those two is the family status. One has it, one don't, but there are still laws, and TWC, we follow state laws which mirror federal law. So anything that's established federal wise, we do have to follow it. So that's a little bit of background information on the education of the laws, what exactly these mediations are different. So with mediation and housing, the difference is parties are still may be employed. So that always makes it a little tricky, because the person filed a charge of discrimination, but they still have to go to work and deal with the same supervisors they've been complaining about. The parties still may live in the property, whether it's a house or apartment. They still got to deal with these people. So that makes it a little tricky as well. The parties may be affected by their living or employment circumstances. In other words, they may get a no renewal of the lease. They may get written up, or they may be terminated. And those are kind of like retaliations. And with housing, the evictions, bad references for a job or a house, all of those go into why did you do that? And that's not right. And also with the employment and housing mediations, there's always a monetary component. They may tell you it's not about the money. It's about this, this, this. Many times I go, okay, fine. Let's take the money out. Now, how do you want to get it resolved? It's about the money. They're looking to be compensated because they feel that they have been harmed. Sometimes they are, sometimes they're not. But, you don't really know until you get into the mediation. And you find out, as y'all know, you find out a lot in mediation, especially the private caucus. They sometimes tell you things that you wish you hadn't known, and you're glad it's private because you could get subpoenaed by it. So it's like, just don't tell me these things. Now, also with the mediations where there's housing and employment, many times we have to explain, this is the law, this is how your case compares to the law, because they got to understand if we say, it's going to be difficult, they got to understand, well, why is it difficult? Well, for example, and I like to give examples, so you get to hear a lot of my examples. Oh yeah, by the way, throughout the presentation, if you hear what I call a Marciism, go ahead, use it, feel free, they're not copyrighted. And I give a lot of Marciisms. Now, how is the law applicable in some cases? Well, for example, I had a case where the gentleman said that he was discriminated against because of his race. we start digging into the case. I mean, and everything. Well, it comes to find out his race did not play a factor in why he was terminated. The reason why he was terminated was he was angry. He came in one day, cussed out all of his coworkers, got into it with the supervisor, and ended up putting him in a headlock. So I had to explain to him that's not discrimination. It's kind of assault and battery. And be thankful that they did not press charges. They just fired you, but you could have went to jail. So sometimes you do have to explain those kind of situations and how the law is applicable to those cases. You know, just because you got fired, you're protected, doesn't mean you have a case. It just means that you're in a protected category. Now, with housing, those are unique because people housing discrimination as in apartments, or maybe they're renting a house or something like that. That could be mortgages. That could be somebody comes in, great credit, they apply for a mortgage, and they're charged a higher interest rate compared to somebody else of, say, maybe another race, color, national origin, gender. Also, too, you may have a real estate agent that will steer one race to another section because they feel like they would be more comfortable there instead of showing them what's available. Somebody applies for a house and say, for instance, as an individual and they have like 3 or more rental properties, then they fall under HUD's guidelines. I had one case where the lady came in, looked at the house. It was wonderful, great, fantastic, everything she wanted. And she says, well, I have to bring my husband back for him to look at it. Well, her husband was of a different race. So they went from charging her one time the monthly rent to 4 times just because they saw her husband. So you run across cases like that, which is unfortunate, but it does happen. Housing cases, there also may be a representative from a fair housing council. So some people will go to a fair housing council. Austin has one. And that Fair Housing Council will assume the representation of that person. So in mediations, you may have the complainant, the representative from the Fair Housing Council. On the other side, you may have the property owner, property manager, an attorney. It may be the HOA. It may be all the parties at HOA. You may go from like 2 people to 8 people in a mediation, and all of them say that they're crucial to be there. So those make it kind of a unique situation. And also too, with the housing cases, you may be dealing with a city authority organization, like the City of Austin Housing Authority, City of Dallas Housing Authority. So you deal with all these different entities in mediation. So it's not just one person that feels that they were agreed, the other person that can hopefully resolve the issue. So moving on. So continuing on, you know, the different things. And now here's another thing. I'm not sure if any other types of mediations do this, but we do, and we do it in and out. Once we get the case resolved, then whether it's housing or employment, we have to talk about settlement amounts, what it is. How do they want it split? Is it going to go just to the complainant? Is it going to the complainant and their attorney? Is a check coming from the respondent? Is it coming from their insurance agency or their insurance carrier that's going to pay this? How many checks are going to be written? Is it one? Is it one just with, okay, this is the amount and they take no taxes out? Is it going to be 2? One, they take no taxes out. The other one is back wages, so they take taxes out. Is there going to be 3 where one's the attorney, then the other amount is split? So you have to have those conversations. Oh yeah. Also, if one of the parties owe back child support, the AG comes involved. And they want, of course, they want their fair share, which is great because they should get it. And so you may be dealing with a whole lot of parties on how is the money going to be split. And the best thing I can tell anybody who gets a settlement in the mediation, and this is my tax advice, go to a tax professional. Why? They know how to handle it. I have no idea about taxes. I let somebody else do my taxes. If they screw up, that's going to be on them. So I always tell them, let a tax professional handle this and do this. Now, moving on. Let's see. What to expect in these mediations? Oh, parties want to be heard in uninterrupted, I'm sorry. So this is a perfect opportunity for, say, somebody who has no legal representation. They want to be heard. They feel like they've never been heard. They complained, and nobody listened to them. So this party now got the opportunity to be heard, which, is great, because a lot of times they do need to get it off of their chest, and that helps with getting to a point where we can reach a resolution. A lot of times we'll tell the party to write out what they want to say. So that way they can go in chronological order of what happened, remember names, dates, everything that's going to get their point across on why are we here right now. Also, they want to know how the law is applicable to their cases. Sometimes you got to explain it, sometimes you don't. Sometimes you have attorneys coming in that don't do employment discrimination cases, or they may be a litigator and they try to litigate the case, and you're trying to tell them, this is mediation, can't litigate here. Also, too, you talk about the different types of resolutions that's available, what's legal, what's not legal. For example, a lot of times when we're trying to get the case resolved, the complainant says, I want my old supervisor fired. Well, we can't suggest that, recommend that, or anything like that, because it's looked at as retaliation. So we have to explain to them, I understand, but they can't be fired. How about training? So you may have to throw out other ideas to get them off of what we cannot do. Let's see. We also have to talk about the compensatory caps in employment discrimination cases. Those cases, they do have caps based on the number of employees that the company has. And the compensatory caps go from 50 to 300,000. Those are just basically, I was harmed, pain, suffering, mental anguish, and the mental anguish could be enjoyment of life, enjoyment of your partner. You had to get psychological counseling. All of that goes into the compensatory cap. And we're not even talking about wages, because we do talk about wages. How much are they out in wages wise? And then you have to calculate, okay, you're out 6 months, 6 months wages. Okay, you got to take out possibly the unemployment, because they got unemployment. Also, you have to look at during this time, COVID, did they get COVID pay? Got to subtract that, because they look at that as you had income coming in. So it's a lot of math involved, and I'm not a math person. Tried it once, don't work for me. Even though I was initially an engineering major in college, I don't know why. I think I just had a lack of reasonableness or whatever, because it was too much math. So, but in those kind of cases, you do have to look at the settlement. Housing the same way. Housing, you have to look at what's fair, what's reasonable, what is appropriate, what's not appropriate, and also too, how they're going to have the checks divided up. And it's usually just one check, and you have to talk to them about, okay, because you received this, let a tax preparer handle this. If they are receiving government assistance in the form of a housing voucher, they do have to let that organization know that they did receive a settlement, because that could affect their ability to renew their housing, to get a housing voucher. So there's a lot of other conversations that go into just settling the case, not just, okay, fine, it's done, it's over with, let's move on. Mediators proposals. Let me ask you this. How many of y'all have done a mediator's proposal? Just raise your hand, chime in, whatever. Nobody? Somebody? Okay, y'all know what mediators, okay,
Yeah,
sorry.
can you clarify what you mean by that, Marcia?
Okay, what a mediator's proposal is, and we normally do it just in employment cases. A lot of times they get to a point where they may ask us to make a recommendation on how we see the case and how we think that the case should be resolved. So that's what a mediator's proposal is. We just kind of, the way I do mine is just reiterate, this is the reason why we're here. You feel like you were discriminated against because of your gender. Manager was treating you differently from your male counterpart, or something to that effect. And then we do a quick analysis of the case, because myself and my co-worker, Faith Penn, who's another mediator, we are both trained to do investigations. So we'll do a quick analysis of, here's the case, here's what we see, and our recommendation is this. And a mediator's proposal is just a recommendation. They can accept it or they can reject it, or it may be a good starting place to get down to some real negotiating, because you may have parties where the complainant feels like they've been harmed and I want 2.5 million. That's not reasonable. And the respondent says, okay, fine, I will give you 2.5 million in monopoly money because I'm not going to give you a dime. So the proposal is just a way to either get the case resolved or give them a more clear-cut, here's a good place to start to get it resolved. Do the mediator's proposal works? About 90% of the time, because what happens is I get thrown on the bus usually once or twice in my mediation, just point blank. I put on a white t-shirt, take a picture of the tire tracks. Why do I get thrown on the bus? Because I can make a recommendation and the attorneys will say, they'll go back to their clients and understand the attorneys get paid by their clients and I get paid by the state. They'll tell the client, well, it's not how I see it, but this is what the mediator thinks. So I get thrown under the bus on that side. Or the attorney for the respondent would go back going, I don't see it this way, but this is what the mediator recommended. And she's heard, conversations in both sides. I think you should take it. So it's not coming from the attorney saves face. I just get thrown under the bus. So that's another thing that will happen. Also too, settlement agreements. Now, there have been a lot of controversies of the MSAs, which I don't understand, but I'm not going to get on that soapbox today. But these settlement agreements, we do have the authority at TWC, myself and my counterpart can write settlement agreements. And the reason why we can write the settlement agreements is a template. The language has already been checked out, approved, whole 9 yards. We just fill in what we need to fill in, or maybe change the language a little bit. Other times it may be the respondent, whether it is the property owner's attorney, the company's in-house counsel, out-house counsel, they may write up the settlement agreements, which is fine. That's perfectly fine. If everybody's comfortable with that, they have the opportunity to look it over, they sign it, and it is binding. So with that, all of those things being said, now let me mention something else with the settlement agreements. With our settlement agreements or outside settlement agreements for employment, and this is strictly employment, sometimes if the parties are over the age of 40, we are required by federal law to put some language in there. And the language is basically saying, because this person is over the age of 40, they have 21 days to decide to sign the settlement agreement. Now, and that's time enough for them to look it over, take it to an attorney, whatever the case may be. They have 21 days. If they don't sign it within 21 days, no harm, no foul, they're not required to. Now, if they do sign the settlement agreement, then they have 7 days of right of revocation. They can revoke their signature within those 7 days. It's kind of like a cooling off period. Even though they may have signed the settlement agreement, they go, I really don't want to go through this. They can. No harm, no foul. We don't have a deal because they are over the age of 40. Now, after the 7th day, on day 8, they can't revoke their signature. It is a binding document. You can't back out of it. You must abide by the terms and conditions that both parties agreed upon. So those kind of settlement agreements are a little different, and we have just that little bit of language in there. So moving on, let's see. Talking about the expectations of what's going to happen. Main thing, parties want to be heard. I try to limit the opening statements of each parties. I try to give them enough time, but I have had opening statements where the complainant spoke 45 minutes nonstop and nobody had a clue what they were talking about. So I try to tell them, be very clear, concise, straight to the point, name things in chronological order. So that way, and we're human creatures, you keep our attention. We see this shiny object and we go, oh, okay. Because if not, we will look for other shiny objects while you're talking and we may miss a lot of points. So I try to tell them, limit it down. That way you're not repeating yourself and you get out what you need to get out and explain, why are we here? Why exactly are we here? Explain how the law is applicable, and that could be on either sides. They want to know, how is the law applied? Is this really discrimination? Should this be filed somewhere else with some other agency? Is it really a contract dispute, which we have no reason whatsoever to deal with that, but people have filed discrimination, saying it's and dress it up as a contract dispute, which it wasn't. OSHA violations, we're like, you got to go file with OSHA. We don't handle those. So those are the things. And the biggest thing, and I know as mediators, y'all run into this, where the parties feel real comfortable with you, they may latch on to you and feel like you're their advocate. And you have to reiterate, I'm a neutral third party. I talk to you and I'm glad you feel comfortable with me because you trust me enough to tell me things, but I don't represent you. I don't represent the other side. I am that neutral third party, or as I call it, I'm that ice cold bucket of truth. It's cold, it's exhilarating, it's freezing, but you got to hear it. So that's what the expectations are in these kind of mediations. So far, do anybody have any questions before I continue on? No questions? Oh, y'all are easy. Gosh. Now, also too, during the expectations part, what are they looking for? And we can give them some ideas of what's reasonable, what's fair, what they can ask for, like job reinstatement. I want my job back. Okay, let's talk about that. They can get their job back. Maybe changes of locations. I don't want to work in this facility because there's something there and it makes me break out in hives. Change managers, because maybe they have an anxiety issue and this manager just don't know how to connect with them and it gets them stressed out. Accommodations. The accommodations could be they need to change their start date because they're taking medication and it's hard for them to get up and function early in the morning, or there may be times that they have to miss because there's doctor's appointments or something to that effect. Another biggie is neutral job reference. Now, people think all companies give neutral job references. That's required. It's not. Companies are only required to say the reason why that person is separated. If your truth, as I tell people, if your truth is ugly, then it's an ugly truth, but it's the truth. So a company can technically say, well, we fired them for cause. Well, why did you fire them? Well, they came to work drunk. And yes, I've had a mediation like that. So we tell them neutral reference. Your former employer only going to say you worked here from this day to this day, and this is your last position. I don't even tell them to talk about salaries. And here's the reason why. Some states have outlawed discussing salaries. And I try to make it a habit not to put in there, if you're going to give a neutral reference, talk about salaries. And here's the reason why. If any of y'all were working somewhere and I say, for instance, I mediated and I resolved the case and you go find another job. You went in, you just hit that interview out of the park. They love you. They think you are wonderful. And you ask them for 150,000. And they go, maybe we getting a deal at 150. They could have said 175. Well, if your former employer says, well, they were only making 50, then they're going to try to lowball you on your negotiations. So my take on it is, if you can go in and negotiate $150,000 salary, I'm taking y'all to go car hunting with me because you did a lot. So that's why I say, don't even mention the salary, because that way that person can move on and maybe be in a better place. Now, the monetary compensation, it could be settlement, negotiated severance, because if they want to leave the company, say they're still working there and it is just so toxic, they don't feel like they can continue on, we could talk about maybe coming up with a ways where it's a severance package. They get so much money, they get paid out their vacation or whatever the case may be. So that's employment. For housing, it could be refund of their deposit. I'm moving out, I want all my money back. Change of apartments. It could be that maybe this apartment, they were having problems with their next door neighbor, and as an accommodation or a request, they change apartments. Or maybe they're going from the third floor to the first floor because now they have a disability and the first floor is more accessible than a third floor apartment. Also accommodations, handrails in the bathroom. You would think that would be easy fix, and most property manager would just do that. No, they won't, believe it or not. Changing the height of the kitchen counter. Now, for me, I'm 5'9", so my counter is fine, wonderful, great, and fantastic. I don't have a problem. Now, somebody who is wheelchair abled, that would be kind of difficult for them to reach the top of the counter. So in this situation, they may need the counter lowered just a little bit. Or say, for instance, there's carpeting in their apartment and they have difficulty walking. It would be better for them to have hardwood floors than carpeting. So this is another thing that they can ask for in housing, to remove the carpet. You know, you would think it's the easy fix and you would think, oh, that's not too bad. It really is. Another one, handicap parking. You would not believe how many cases where the property manager says, well, we can't give them a handicap parking space, but they're handicapped. But we can't. But they're handicapped. But we can't do that. But they're handicapped. Well, if we do it for one, we got to do it for all. But they're handicapped. So some of the things you go are common sense. Sometimes it's not common sense in their realm. Also, too, reimbursement for, say, moving expenses. They moved out of the apartment. They just couldn't take it no more. They want to be reimbursed for moving expenses, maybe the U-Haul, getting their utilities disconnected, reconnected, different things like that. So those are remedies for housing cases as well. Let's see, moving on. Now, I mentioned the compensatory caps for employment. The compensatory caps are based on the number of employees the company has. For employers 15 to 100 employees, the maximum is 50,000. For 101 to 200 employees, the maximum is 200,000. For 201 employees to 500, the maximum is 200,000. And any employer over 500 employees, the maximum is 300,000. Is that amount guaranteed? No. None whatsoever. It's just the cap. And these are guidelines, and it's not carved in stone. You got to do this. There's a lot of other factors that's involved in a monetary settlement for employment, like how long have they been there? What's their salary? What type of discrimination is it? So we have to look at all of those things when we're discussing with them. What are you looking for as a resolution? I'll give you another example. I had an employee. He said he was sexually harassed by his manager. Well, come to find out, he was not sexually harassed by his manager. He was sexually harassing every female that came into the fast food restaurant. But he wanted, as a settlement, 2.5 million. And he was only getting $8 an hour and working 20 hours a week. Yeah, he didn't get it. He got 500, just $500. But you still have to have those conversations on why that's not reasonable, why that can't happen. And hopefully it will penetrate and they go, okay, makes sense. So moving on, next ones. Let's see. All right, the mediator's proposal, we can get into that a little bit more. The mediator's proposal just gives the parties a proposal as a way to get the matter resolved. So the way I do those, like I said, I analyze the case for them. You know, it's just based on everything that they give to me. And this is my recommendation. So it's just a way to get the case resolved. Attorneys like it because that way they can kind of evaluate, if I go to litigation, what is this case worth? So it kind of gives them a tool on, do I really want to go to litigation, or can we work together to get this resolved? Also, too, it's a good way to continue discussion so we can get to that point to reach that resolution, because I may do the proposal. They initially may say, well, we want to think about it, or no. And then they come back going, we want to do that, because they have an opportunity to say, I want to get it done now. I want closure. I want to move on. So that's the mediator's proposal. Everybody do them differently, but with employment, you do a lot of them. It may be just in the middle of a face-to-face mediation, and currently our agency is not doing face-to-face. We only do Zoom and telephonic. So when we were doing face-to-face mediations, it could be, I would give both parties a number, give them 5 minutes to talk about it, and then go into each room going yes or no. And it's just a number. And a lot of times I got those resolved because that was a number where they can say, well, it's not what I see the case valued at, but that's what the mediator says. Or on the other side, I don't think the case is worth that much, but because the mediator will go ahead and pay this. So again, get thrown on the bus. Settlement agreements. Now, our settlement agreements, There's standard language in our settlement agreement, whether it's TWCs or outside. They release everything. If we get a resolution, the case is closed, it's done. You can't turn around and close the case with us and then go file with the EEOC. You cannot do that, because once you file with us, we notify EEOC and we work the case and we tell EEOC the final disposition of the case. Some people think, oh, I'm gonna file with TWC and EEOC. That's called a duplicate case. It will get dismissed because it's two cases pending. You can't have us and EEOC work it because we work under the same rules and regulations and laws. So that's part of it. Confidentiality. Our settlement agreements is confidential. All the terms and conditions are confidential. Now, there are certain times that confidentiality may not be completely confidential, like school districts. They may have the settlement agreement part of an executive board meeting. Well, the board needs to know because the board's writing the checks, or a municipality like City of Austin, City of Dallas, that would be a municipality, something like that. So those are not completely confidential, but they are confidential to a certain point. The confidentiality can be breached if there is a breach of any of the terms and conditions of the settlement agreement, because confidentiality goes out of the window and the document itself becomes part of the litigation. So that's one of the things where it is not confidential. Mutual non-disparaging clause. Now, let me touch on this, and I think everybody will kind of appreciate it when I explain. It's just basically saying that parties can't talk about each other. They can't go to social media. They can't go to any job websites or apartment complex websites or the actual employer's website and post negative or derogatory things about the company or the employees. Now, the reason why I say this is really, really important, and you will appreciate that, is we live in the age of social media. And I know a lot of y'all, I know myself, I have a social media account, and you will see these videos that go viral of somebody doing an epic meltdown. You also have people that feel like, I'm mad, or as I say, I'm mad, I'm pissed, and I'm gonna make you pay. How do they make a employer pay? Put negative stuff out on the internet. If you put enough on there, give it 2.5 nanoseconds, it goes viral. What happens? The employer's reputation and brand is damaged. Individuals may be named that they did not do, especially sexual harassment cases. If a man is accused of sexual harassment and it has nothing to do with it, that person lied, now this man's going to get a bad reputation because he's been accused of sexual harassment. Now you can imagine if he's married and he has to go home and tell his wife, I was accused of sexual harassment and I don't even work in the same building as this woman. That's going to be a hard conversation. So that's why the mutual non-disparaging clause, because people go to social media and they will say things that is very ugly, very distasteful, just out and out wrong. Even if they post a retraction, you're still going to Google the case or Google the employer, and the negative part is going to come out and not the retraction. So I always say mutual non-disparaging clause. Also too, the terms and conditions of when everything is supposed to be settled. If they sign the settlement agreement and there's monetary compensation involved, how soon do they get the checks? Method of delivery. Since our agency, we pretty much, well, our department, we pretty much work remotely. We work from home. We will have the employer to FedEx the check to the complainant. Same thing with housing cases. So that way we have a tracking mechanism. We know when it's going to get there, but we also put in the settlement agreement the time frame. Is it 7 days after they sign it? Is it 14 days? Is it within 30? You know, something to that effect. So that way they got to adhere to that time frame to get the check to those parties or do what they were supposed to do so we can close the case. If they don't do that, then there's methods to enforce the settlement agreement. If it's TWC settlement agreement, we have the authority to enforce it up to going to litigation. If it's an outside settlement agreement, unfortunately, the parties would have to obtain their own attorney and enforce the settlement agreement. Now, admission of no liability for either housing or employment. If we resolve the case before the investigation has been completed and a determination has been made, we can't say that they're responsible or they're liable because we have not done the investigation and we don't know for a fact. So we always put that in there, no admission of liability. We didn't do it. That's the story, we're going to stick to it. Some people complain about that, others doesn't make them a difference. Now, also too, I talked about the employees or the person over the age of 40, the Older Workers Benefit Protection Act. That's the same thing. That's the federal law where it just gives them a double protection for them to make a determination. And the reason for the Older Workers Benefit Protection Act is really for, say for instance, somebody got laid off and they feel like their rights were violated. And they feel like, okay, it's because of my age. So we get a settlement agreement. They're not forced to sign a settlement or a severance package immediately without them knowing and understanding their rights. If it's a severance package where people get laid off or terminated, they want to make sure that their rights are covered. Am I going to lose medical benefits? Am I going to lose my pension? Am I going to lose my retirement? So these are the things that they would need to check out with an attorney or someone else to make sure that their rights are covered. So that's where the Older Workers Benefit Protection Act is just a double layer to make sure that an employee's 40 or older are treated fairly and they don't get messed over in the process. So next, let's see. Oops. Now, mediation in the age of COVID. We've all dealt with COVID. As of March 2020, life as we knew it changed. I always say, okay, pre-COVID and now, and it just seems like pre-COVID is just like a fairy tale, it's history. It doesn't even kind of resonate anymore because it's just like, this is what we're dealing with now and just going and dealing with the day-to-day activities and everything else regarding COVID. Well, housing and employment, we also have to deal with COVID, and we're now dealing with the fallout from COVID. During COVID, we had to deal with the mask and vaccine mandate. We still getting the federal mandates. Some companies do require employees to get vaccinated, especially if they have maybe a government contract. During the time when it was going back and forth, we had to deal with who wanted to get vaccinated, didn't get vaccinated, who could opt out of getting vaccinated, did they violate their law? So we had to deal with those as well as mask. Is mask okay, not okay? You know, so we dealt with the discrimination part as well as that's kind of treading into OSHA's territory, but if it's part of the mediation, you kind of have to get into it. Safety precautions regarding any type of mediation face-to-face. We opted right now not to have face-to-face just for out of abundance of precaution. And then we found out it works even better because since our agency deals with private employers throughout the whole entire state of Texas, we're talking about from Brownsville to Amarillo, Houston to El Paso. That's a lot. And sometimes we have attorneys from out of state that would have to fly in for the mediation. Now, since we can do it Zoom or Microsoft Teams or Adobe Connect, they like it because there's no expense that they have to pass on to their client flying in to do a face-to-face. They just get to see me from the waist up and I'm all dressed and everything. And no, I do not stand up because right now I got on sweatpants and fuzzy slippers. So, but it's nice not to have anybody inconvenience with the airport, airline delays, getting stuck, even though Austin is wonderful. Some people do want to go home. So we deal with those, the virtual platforms as well. The social media rants, believe it or not, after March 2020, those have increased tremendously. And you will see these people go on these epic rants and it's just like, what are they thinking? What are they doing? And the first thing that we hear when somebody gets fired behind it is, it's my civil rights. It's my constitutional right. Okay, you're right. It is your constitutional right. You do have the right for freedom of speech within certain parameters. You know, there's certain things, the old comments, you can't yell fire in a crowded movie theater. You can't yell there's a gun in a crowded mall because you know you're going to put other people in harm's way or safety. It's going to be a safety issue. But you can say whatever you want to say. That's your right. Now, with that right comes responsibilities. The responsibility is When you say what you want to say, know your audience. Who's your immediate audience? Who's your expanded audience? Who has that wonderful handy dandy cell phone streaming it right now while you do this rant and you say whatever you want to say? Now, those are responsibilities. It's your responsibility to know your surroundings, I would say it. Consequences. Here's the consequence of your rights. People may love what you got to say, applaud you, want to get your autograph, the whole 9 yards. It does happen. Some people don't even react at all. They're going, okay, fine, no, nothing to see here, and move on. The negative ones, those are the ones that people don't realize. You may have that right, but if you work for a company, companies usually have ethical guidelines and their policies and how you should or should not conduct yourself. And as you being an employee, do they want that negative connotation attached to that company? Did you go from an asset to a liability? So those are the consequences that people don't understand. And now there's been more rants and people have gotten fired for these rants, whether it is videotaped or they make comments on Facebook. Those things can get you fired and people don't realize that, but it does happen. Political and racial divisions, those are huge because you will have difference of opinions. You will have difference of how you view the world compared to someone else. We deal with those, and the mediation, they're very touchy, they're very delicate, and you have to tread very, very lightly because sometimes in private caucuses, they will say things that sometimes you just can't let go. And I have personally discontinued a mediation because they were being racially insensitive, borderline, just really offensive. And I told them, we got to stop because I cannot jeopardize the comfortability and the safety of all parties by you performing this way. I've also had threats where I had to stop a mediation because of the safety of all parties involved. I can't deal with threats. Threats are not going to happen. That's not my mediation. I will stop it in a heartbeat because I can't guarantee the safety and I'm not going to have anybody subjected to a negative rant, especially if it's very decisive, racially insensitive, or derogatory. That's not going to happen. How do employees deal with, how do employers deal with employees regarding COVID and the long-term COVID effects? Is it considered to be a disability or not disability? How do we handle that? So these are unique conversations now that I hadn't had to have in the past, but now I had them. During the height of COVID, I also had numerous conversations regarding school teachers and doctors. And yes, they were essential employees, no doubt about it. But we also had to realize they were people. And with those people, if they had a disability and they asked for an accommodation, we have to remind the employer, you got to have that conversation regardless if they're essential or not, because they're employees, they're people. And if somebody has a compromised immune system and they can't be around others for the, the fear of maybe contracting COVID or one of the variants and stuff like that, but they're essential employees, we still have to tell the employer and remind the employer or tell them you violated their rights. You got to have that interactive conversation. You got to find out what their safety and comfort level is. What does the doctor say? You can ask for documentation, but also too, you have to keep in mind. So those were conversations we had during the height. Now we're dealing with the long-term effects. Those are disabilities. And employers, sometimes you got to have those conversations. In housing, we had to deal with the COVID situation. Well, a house is quarantined because they have COVID. Maintenance people couldn't come in and do repairs because of fear of COVID. And a lot of maintenance weren't going in doing repairs unless it was just absolutely necessary. For example, maintenance would go in and change the filter on the air conditioning unit. They wouldn't go in because they can just leave the filter there. You can change your own. But if it was like, okay, something wrong with the electrical, or maybe a huge massive water leak. Then they would go ahead, mask up and go in there. But you also had to deal with that. Now, also too, during that time, the state was receiving federal funds from the federal government for rental rental coverage and everything else. Well, some people didn't do what they were supposed to do. So now we're dealing with the evictions. Who got evicted? We don't mediate evictions, but we also have to look at, did everybody get evicted the same? Now, when they go try to find another apartment, is one person going to be charged 4 times the rent and they were evicted compared to another person who was evicted and they were only charged 1 time the rent? So we're dealing with those kind of conversations that we didn't have to deal with before. Also too, we were dealing with property managers. They got creative to get rid of get rid of tenants. They couldn't evict them because they were behind on their rent, but they would evict them for any other clause in their lease agreement. So they said, well, they violated the lease. They were too noisy. They may not be noisy, but they went ahead and got evicted, or a non-renewal. A non-renewal is just like you got kicked out of the apartment. It's very hard to overcome, and it makes it difficult to find another apartment because they're going to ask, well, why were you non-renewed? That's happened. Now, the last thing is, during the age of all of this, and regardless of what type of mediation you do, self-care. It's very, very important, because many times we were working remotely. We didn't have the connection of dealing with other people because of the safety protocols, or just the, health reasons, or whatever the case may be. So a lot of times you didn't really get a chance to decompress and step away from the mediation. And they can be very, very intense. They can be very draining, but you wouldn't have time to decompress and do the things that you wanted to do. And it became difficult because you started absorbing the people's problems that you're mediating. You started absorbing them into your personal life, or taking them home with you, or 2 o'clock in the morning, waking up about them. So those are things that you have to, with this age of COVID, step back, go, I did what I could. I did the best that I can. I did everything I possibly could do, but it just wasn't time to settle, or the parties just didn't want to settle, or they weren't interested. But you can't take it home with you, and you can't take their problems home, because after a while, us good mediators will get burned out, and you can't get burned out doing a mediation, because you have to be engaged. You got to be on your A game. You got to feel while you're doing the mediation. And if you get so jaded to everything, it starts compromising who you are as a very good mediator. So with that being said, any questions? And please ask me questions. I went through a whole lot of information, and y'all more than welcome to get copies of my slides. Have them, please. Yes, ma'am. Let me put my glasses on. Is that, okay, I'm sorry. Pronounce your first name. Thank you.
Me?
Okay. Okay. I'm not going to screw up nobody's name because I hate screwing.
Oh.
So,
No, it's okay. I think I was just raising a thumb saying, yes, if you could, if you'd be willing to share the slides, we can
most
email
definitely.
them to everyone afterwards.
Oh, most definitely.
That'd be awesome.
Please, please. Any other questions?
I have a comment. Comment, question.
Comment, questions?
Hey, Marcy.
Diane,
How are you doing?
I'm fine. How are you?
I am fine. I wanted to know, and first of all, I love how you finished with self-care, because I'm a big believer in that and all.
It's important because I work from home, so I don't have the opportunity to, hang around with my coworkers and stuff. And working from home, sometimes you got to remember, I got to stop, and it's home now. So I've made myself close my laptop, turn off my monitor, and walk away, because if not, I'm gonna get burned out. And if I'm burned out, I can't do a good job. I can't. And that's a detriment to anybody. And, that's wrong, because if I'm gonna sit in this chair and say, I'm gonna be a mediator and I can't do the best of my ability, I can't give you 100% every time I sit in here going, thank you for participating, then I don't need to be a mediator. I really don't.
Yeah, very good point. And especially with home and office, kind of the same thing. Yeah, we need to do something to separate the two.
Right.
So I have been involved as a kind of an offsite supervisor for the Workers' Defense Project for a lot of years now. And you probably know that they do kind of similar things, but they're often doing it for people who are either immigrants or undocumented, or don't speak English, construction worker kinds of things, and they are looking to protect people's rights and stuff. And so I'm wondering for you, if you see a lot of cases where either that there is some an undercurrent of racism or some kind of bad faith from employers that get you, that make you react.
I've seen it quite a bit, and they would make a comment in a roundabout way, but I knew exactly what they were saying, because this person either had an accent or didn't speak English. And in our mediations, we do provide translators free of charge. So if anybody came in and they needed the mediation translator, we provide translators. Even, if they need sign language, we provide that free of charge. But yes, I've had employers to insinuate, because this person didn't speak English or they spoke broken English, that they were less intelligent. And I stopped one day and I asked him, I said, okay, how many languages do you speak? He says, one. I said, okay, but they speak two. So you monolingual, they're bilingual. What you think about that? And they had to stop and go, oh, they're not dumb. No, they're not. They're really not. So I've had that. Or for a fact that I've had employers where they have threatened to call immigration because they assumed or speculated maybe they were undocumented. And they would do that as a scare tactic to pay them less for the same work. So you would have different things like that. And those things irritate me, aggravate me, excuse my French, piss me off to no end, because it's not right and it's not fair. Because if somebody goes in and does the work, they should be paid the same as anybody else. No ifs, ands, or buts. And they should be treated the same way. Housing cases, I've had those where the property manager has propositioned single women or women that were the head of the household and there was no man at the house. I'll fix your plumbing and in exchange for XYZ, sexual favors. Those are wrong. Those are so wrong. Or I'm gonna call immigration and I'm gonna jack up your rent. I'm not gonna do repairs. I've had things like that, and those irritate me, because as a person, we should care about our fellow man. And to do things like that go against who I am as a person. And sometimes you have to gently remind them in a nice way that what you're doing is discrimination. Luckily it's confidential, but let me just go ahead and tell you, if you go out there past this mediation and continue to do that, you're going to have problems. You're going to have so many lawsuits filed against you. It's not funny. And if there's enough, then it becomes a class action lawsuit. Then you're going to really pay, and your reputation is going to be damaged because it's going public. So yes, I've had ugly things like that, really ugly.
I have a quick question. This is Ted.
Yes,
What
sir.
kind of training and who provides the training for that type of mediation?
Okay, for housing, it's pretty kind of closed, but employment, EEOC are looking for contract. And I don't know if EEOC does any type of training. to do employment. I don't know. I'm gonna have to find out. But if you do decide to sign up for a, sign up as a contract mediator and do employment, at the end, my contact information is on the slides. Feel free to reach out to me and I can help you out. I can give you a quick crash course. So that way you can get in there and you can feel like you're totally in control, even though you may be going, oh my gosh, I'm way over my head. You're not over your head. So I don't know, but feel free to reach out to me and I can help you out free of
Thank you,
charge.
appreciate it.
No, I take that back. I will charge you. Cup of coffee at Starbucks.
Marcy,
Okay,
I'm
that's fair enough.
Yes, ma'am.
sorry to break in. I just, there's someone on the phone who's been unmuting themselves, and I think maybe they have a question. It's a 512 number that ends in 179.
Okay.
Is somebody trying to ask a question from a phone?
I think that was Ted that just asked.
Okay. 'Cause I
Oh,
know-
I'm sorry. Okay.
I did see a phone number
That's it.
pop up and I didn't know if they were on the phone and they couldn't join Zoom wise or what. So,
Okay, yeah, sorry.
Marcia,
And Carl I see Carl has a raised hand.
yes, sir.
a couple of things, Marcy, and I know we don't have a lot of time, but as you began the presentation, you went over all the laws for
Mhm.
both employment and housing, and that's a bunch of laws. So one
Yes,
thing
it is.
one thing I'm just curious about is how much of that do you have to know totally down to the last little bit, And the other thing, which really
Mhm.
is sort of more important perhaps, is the mediator's proposal.
Okay.
Now, that's something that I've never really gotten into, and maybe many of the mediators haven't either. I'm not
Mhm.
sure. I was wondering if in that you could be, well, probably happens, but charged with or accused of losing objectivity. And then how vulnerable does that make you as far as suits go, or what liability might you have
Okay.
after that happens?
Fair question. Very, very fair question. The mediator's proposal, both parties have to agree for me to do a mediator's proposal to begin with. It's voluntary, so they don't have to accept my proposal or not. My summation, I always put in there, this is my personal opinion, and it has nothing to do with if the case goes to investigations or will this information be shared. So it is just strictly my opinion based on all the information that was introduced to me and doing a quick analysis. Now, I've never had an issue with the mediator's proposal. Sometimes they go, well, I don't really agree with what you see, but I'm accept it anyway. But they know, and most of the attorneys that I deal with are amenable to mediator's proposals. So it's very low, if any, risk. Also, too, sorry about that. Also, too, we are pretty much covered because we are a state agency. So I personally cannot get sued because I'm working on behalf of the state agency. They would have to sue the state agency. Have people tried to sue the state agency? Not because of me, because they just didn't like the way overall we handled the case. So we have very, very little liability in regards to that. Now, the contract mediators, they're still contracting with the EEOC, so they pretty much follow the same guidelines on that. But with employment and housing, it's such a niche field, you end up dealing with either the same attorneys or the same law firms over and over again. So it's pretty much established and expected that you may end up doing a mediator's proposal. Every now and then they have no idea, but most of them do, and they're okay with it.
Okay, well, thank you. And I enjoyed your presentation. Thank you.
Okay, now, one other question, I forgot to address that. The laws, do you have to know when the law was established and all this other stuff? No. Can you do a whole lot of cheating and prepare? When I first started with TWC, it's like, okay, this case is disability. Okay, let me look at the laws for disability, and you can look it up at EEOC and it will give you the guidance on this is the law and this is how it's applied in this situation. It's just a guideline. After a while, and after you do enough of them, you start to know them like the back of your hand, and it's easy to rattle off. You know, it's just like, okay, can somebody have a service animal in their workplace? Yes, they can. If it's a service animal and it's needed as an accommodation, yes, they very much so. Can they have it in an apartment complex? Yes. Can you restrict the breeds of types of dogs that they can have as a service animal? No, you cannot. That's against the law. Can they have a emotional support animal? Yes, they can. Are they going to be charged a pet deposit? It's not a pet, it's a service animal. It's working. Are they responsible for the damages after they move out? Yes, it's just like anything. If your kid punch a hole in the wall or draw it up in crayons, you're responsible for those damages. So after a while, it gets a lot easier and you can rattle them off. At first, it's overwhelming and daunting, but the more you do, the easier it gets. And after a while, you just can rattle it off. And then you realize, I need to know these laws because I got to educate myself so I won't get taken advantage of. If I walk into some place and somebody see, oh, I see a little bit of gray hairs, and they're going to discriminate against you because they assume that you're a certain age, or they see you with a limp and they assume that you're disabled. Not that maybe you went running the day before and you hurt your foot. Those kind of things you do have to know to protect yourself personally, because you don't want nobody to discriminate against you personally. And if you know it, then you can protect yourself personally as well as be real effective in mediation. So it's a lot, but it's easy to learn. It really is. Because we thought getting our 40 hours was difficult. We thought that was overwhelming, and we had panic attacks every time they said role play. Now we're pros at it. It's just like, oh, that's no problem. None whatsoever. We all got, PhDs in mediation right now because we've done it so much. But somebody coming into it, it's daunting and overwhelming. Same thing with the laws. It's daunting and overwhelming. After a while, it's like, I can do it in my sleep.
You're not required to be an attorney, I don't
No.
imagine. Yeah.
No,
Thank you.
definitely not.
Okay.
Not at all. And like I said, I crack jokes in my mediations. I go by first names. I don't go by titles because people get so caught up in titles. And I tell people all the time, you can have title of CEO at 10 o'clock, 2 o'clock, your title's unemployed. Who are you behind the title? That's the person I want to deal with. The person, not the titles. I'm not impressed with titles. I don't care what your title is. Who are you as a person? Are you going to be able to work with me to get this resolved? That impresses me. And some people come in going, I only have a high school education. I'm just like, okay, but you got worlds of wisdom. And that makes you just as important, and even more so because you have that wisdom. Everybody can got book sense, but who has common sense? Common sense is going to take you a lot further than book sense. Book sense, okay, everybody can read and regurgitate it, pass the test, but common sense, how do you apply it in the real world? That's the main thing.
Thank you.
You're welcome. Any other questions? So how many are going to sign up to be contract mediators for EEOC? And I can give y'all a crash course on, here's what you need to do. Okay, nobody? Seriously? Okay.
I wanted to, sorry, I'm jumping in again, but I know, I think maybe somebody did have a.
No, I just want to say, instead, I may contact you. I'm interested in the
Okay.
EEO.
Okay, also too, if y'all ever want to shadow me on a mediation, as long as the parties agree, I'm fine. Y'all can sit in and see how I operate. Y'all will probably crack up laughing because in my mediations, like I said, I tell jokes. I also tell a lot of stories about my mother, who's 83 years old and has a boyfriend. So y'all find out the adventures of my mother as well. And they crack up laughing and everything else. And by the time the mediation's over with, even though they didn't want to pay this amount, they didn't want to agree to it, they agreed to it. Everybody signed on the dotted line. I'm like, yes. So feel free to reach out to me anytime.
I just wanted to mention that we did schedule this meeting longer than we normally do. So
Right.
Just to let everybody know that we understand if you have to leave, but we actually, still have about 5 minutes in our scheduled time.
I'm gonna have to, because I got about 3 minutes to get ready, and then I'm getting ready to jump in and do another mediation, believe it or not.
Well, I
Mar-
did just want to mention before anyone leaves that we have a couple surveys that I'm going to send. One of them is about whether people want to go back to doing in-person meetings or continue virtual meetings. So I'm going to send those, and please open them so that you can fill them out after the meeting ends.
Okay, so that's my contact information. That's my work. Yes, I also do HR consulting on the side. So I just started my LLC. So reach out to me at either number. If I don't immediately respond to you, if you call me, 9 times out of 10, I'm probably in a mediation. So I will get back to you. But if y'all ever interested in sitting in and shadowing, that's fine. If y'all do decide to sign up and be a contract mediator, let me know. I can give you a quick crash course on the craziness of it, and you will end up loving the craziness. So anything I can do to help y'all, please feel free to reach out to me. Okay, guys?
Marcy, thank you so much. This has been such a treat and so much valuable information.
Oh, thank you for having me. Like I said, I am honored to speak to my co-host. When I did the presentation at the TAM conference, it was nerve-wracking. I talk all the time. I talk for a living, but it was just the idea of talking to my peers that was just so scary. It's just like, okay, will they be receptive? Because y'all, I'm talking to my people, as I would say, my tribe. I got to make sure I impress my tribe or I'm gonna get kicked out. So it was kind of scary. I was going through a little heart palpitations this morning going, okay, I'll be fine, I'll be fine. But it was fun. It was a pleasure. And thank you so much for asking me to speak.
Well, it was.
Thank you. Very informative and very clear. A lot of information. Thank you so much.
Thank you, guys. I gotta go because people are calling me. Y'all have a good one.
Thank you. Bye, everybody.